Everybody, welcome to our weekly live stream show. Still currently don't have a name for it, but we will figure that out as we kind of go along here. Today, I do have two great guests. I have Andrew Gordon from the Gordon Law Group, and I have Carlos Martinez. Welcome, guys. Thank you so much for being here. I'll kind of let you all explain who you are, what you do. I will let our guests go first, so go ahead, take it away, Carlos.
Thank you, man. Thank Jacob, and thank you, Andrew, for having me on today. Happy to help as much as possible. I know you guys have had a lot of questions regarding bankruptcy and Celsius, Voyager, and 3AC questions, I'm sure. So I've pretty much been in bankruptcy for the last 12 years. I started off as a paralegal, then kind of worked my way up to a law clerk, and now being as a senior bankruptcy associate for the last 4 years at a firm here in New Jersey, the law offices of Skura. My main specialization is Chapter 11 bankruptcies. Been doing that pretty much only exclusively for the last 4 years. And now with Web3, just kind of serving as a business and legal consultant for NFT projects, Web3 companies, and incubators mainly. Thanks again for having me, guys.
Yeah, fantastic. Andrew, go ahead.
Carlos, yeah, it's great to have you on the show. And to introduce myself, for those of you that don't know me, Andrew Gordon, I'm an attorney and CPA and the president of Gordon Law Group. At Gordon Law, we mainly focus on taxation, and especially in the area of cryptocurrency. The vast majority of our clients are in crypto, and we've been in crypto since 2014. So we're not new to the area by any means. And I know many of you may be listening and thinking, oh, shoot, another video about how I need to pay taxes. But in fact, we're going to be talking about a lot of different ways that you can use bankruptcy code and potentially even tax code to your advantage. And so one of the things that I try to do for my clients is to look at their situation, but also the parts of the tax code which are clear, and then the parts that maybe there is some wiggle room and places to be a little bit more aggressive. And we'll talk about some of those today as well. So I'm glad to be back on the show this week, and look forward to this discussion that I know impacts a lot of people in this group. So really looking forward to it.
Yeah, finally, I'm Jacob. I'm the social media manager for Gordon Law Group, and I will be hosting. I'll kind of be guiding the questions and everything, getting everything like on a smooth track. And kind of like what Andrew said, some of you might be like, okay, more tax information, but the more tax information that you know, the better off you're going to be and the more you're going to save. So it's very important stuff. So what I'm going to do is I'm going to kind of kick things off here. We're talking about Celsius and Voyager, and I'm sure a lot of people that are in the crypto community are already pretty much aware. The platforms Celsius and Voyager filed for bankruptcy protection after suspending account withdrawals. Celsius kind of operated like a bank, taking customer deposits and lending them out on a so-called decentralized, finance products to kind of generate high yields. And so we've been getting tons and tons of questions about from users if they're going to get their funds back, what's going to happen, is your crypto safe, can I claim these losses on my taxes, and we're going to cover all of that. But first, I kind of want to kick it over to Carlos a little bit about bankruptcy. So a lot of people aren't kind of aware of bankruptcy law, what's kind of going to happen. So I kind of just want to knock out a few basic questions here. So my first one basically is just, what does the bankruptcy process look like for a company?
I'm going to try to keep this brief for you guys. But it really is based on this process, right? The debtor filed for bankruptcy. At the moment that the debtor files for bankruptcy, a bankruptcy estate is created, okay? And there's also an injunction that goes into place that's pretty much referred to as the automatic stay, okay? The bankruptcy estate is then created. It's made up of pretty much all of the assets of the debtor, wherever located. The estate is managed by the debtor in possession, which is really just the management of the company itself. If for any reason the office of trustee, who is the arm of Department of Justice, feels that management can't handle the management of the business, they will either appoint a trustee and kind of oversee the whole bankruptcy play out. Okay. Then a official committee is appointed, usually made up of the 7 largest unsecured creditors. And the purpose of this committee is to make sure that the interests of all unsecured creditors are protected. And their involvement is really just to make sure that, the pre-petition actions of the debtor were not fraudulent, that the debtor was doing the right things, there were no mismanagement of funds, basically anything that would speak to bankruptcy fraud, which is a legal term of art here in the bankruptcy world, which basically means that, you're either trying to hinder, delay the bankruptcy process, you're hiding assets, you're forging documents and stuff like that. Then the creditors will, have a chance to file what's called a proof of claim. This basically is a formal document with the bankruptcy court that evidences your debt, and you attach whatever evidence you demonstrate, whether there was some type of agreement between you and the debtor being the company that filed for bankruptcy. And from there, it's really just a matter of investigating the pre-petition actions of the debtor and the post-petition actions of the debtor themselves. Like I said, whether they've mismanaged the company, or whether they need to hold their position, subpoena documents, subpoena information, rejection of contracts, right? Seeing if there's any preference actions or anything that could be clawed back into the state, right? When I speak about the preferences, I'm really talking about anything that the debtor may have paid out within the last 90 days prior to filing the bankruptcy. And then from there, it's, the debtor, after all the investigations have been made, then debtor will propose a Chapter 11 plan. Okay, so the debtor really has the first 120 days from the date that the bankruptcy was filed. The debtor has the exclusive right to file a plan, and this can be extended for up to 18 months. But at all times, the debtor is only going to have 300 days to file a plan. And then once it does file a plan, the plan will outline how the creditors will be treated, how much they expect to get back, and then really lay out the priority of who will be paid first. In the process of bankruptcy, usually administrative expenses get paid first. For example, bankruptcy counsel's legal fees or any operating expenses that the debtor has to pay out, post-petition taxes, and then from there it's secured creditors. And at the very last is really the unsecured creditors, right? Which ordinarily only see pennies on the dollar. The bankruptcy plan process, could take anywhere between a year, right, until it's confirmed, if it's able to get confirmed. At a real basic level, in order for a plan to be confirmed by the court, the company or the debtor really just has to demonstrate that it has the ability to present a feasible plan, right? That it could operate as a going concern, and that it can make the payments that it's proposing to make under the plan. So this whole process can take anywhere from a year and a half to 2 years before you see any real results from the bankruptcy themselves. So I try to keep that short.
No, that's perfect. So this isn't going to be a speedy ordeal. This isn't going to happen quickly. No. It's not going to happen when you wake up tomorrow.
No, definitely not. Definitely not. Like I said, the debtor has 300 days, right? So roughly about a year before you can see a plan. And then the plan can get amended thereafter several times, right? Sometimes you'll see 10 or 15 amendments, right? The courts try to keep that number limited, but that doesn't mean that it can't keep amending the plan as necessary.
Sure.
So Carlos, they only need to file the initial plan within the first year, and then they can amend it thereafter. Is that how that works?
That's exactly how it works. So, if you really think about it, right, a debtor could essentially file its plan, and it could be kind of just throwing something at the wall because they really haven't finished their investigations yet. Especially with these big bankruptcies, they have a lot of investigation to do, right? Subpoenas, depositions, they have documents that they have to go through. So, just imagine trying to do that all in less than a year, right? So the deadline is 300 days. And then from there, it's could be pretty much amended every single time thereafter, right? You keep going back to court every single time, right? And the creditors do have the right to object to the plan, right? If they feel like they're being unfairly treated or that the debtor could pay out more that they could, right? So that's why it's constantly being amended.
And so is the total amount of time that it can take until a final plan is approved, is that pretty much open-ended, or are there any statutory limits to how quickly it has to occur?
So that's kind of when the court steps in, right? The court, there is no deadline that you have to have a plan confirmed by a certain specific time. But the court can issue that order and say, you know what, we've been down this road plenty of times. It's kind of, it's the 11th hour. We need this plan confirmed, or if not, then the case could potentially be dismissed or converted to a Chapter 7, right? So if the debtor can't file a confirmable plan by then that abides by the bankruptcy code, then the court can definitely step in and say, this is the deadline for you to file a plan, and we can't go beyond that deadline, or a confirmable plan.
Got it. Yeah, that makes sense.
Definitely. So are there any other types of similar situations involving any type of like financial institution that you can think of?
I'm sure you guys have heard of, or maybe you have, Andrew. I don't know how old you are, Jacob. Lehman Brothers in 2008. I mean, huge bankruptcy, man. That's literally the biggest bankruptcy in United States history, right? I think it had over $600 billion of assets and liabilities. And it was mainly one of the reasons why we had the market crash in 2008, right? They kind of got into these risky mortgage-backed securities, and then they also owned 4 or 5 different lenders, and they were issuing no contract loans, right? Sounds kind of risky. Sounds kind of like what Celsius was doing a little bit with some of these investments, right? So that's one that I thought about immediately. And that, believe it or not, that case started in 2000 and I want to say maybe 8, and that's still going on, right? So we're talking about 17 years later, right? It's crazy, and it's still being liquidated.
Still going on. That means the unsecured creditors have not been paid.
That is unclear. I think they may have gotten paid some, right? And the thing about unsecured creditors, they get paid based on pro rata, right? The percentage of your claim, right? So if Andrew, you have a claim for $100,000 and I only have a claim for $5,000, you will get paid faster than I do. I'm like literally at the bottom of that totem pole. I more than likely won't see any money. Right. And that's what you've been seeing. So Lehman Brothers has huge unsecured creditors. The biggest ones are probably going to be the only ones that get paid the money. Anything that they're able to liquidate.
Wow, that's very interesting. So it's not just distributed across everyone depending on the amount. It literally, if you're a bigger fish, you might be paid, whereas someone else that's smaller won't be.
That is correct.
Wow.
Yep, that is correct. Yeah, and I mean, I've seen that from big bankruptcies to small bankruptcies, man. Sometimes, the unsecured creditors come off. Like, for example, Mt. Gox, right? I mean, that's a very interesting situation because at the beginning of that case, the unsecured creditors were not going to get anything. But 10 years down the road, now they have $9 billion to distribute, right? I mean, that's great for the unsecured creditors. Right, but that rarely happens. Rarely happens.
Only in crypto.
Right, exactly. But who would have known, right? I mean, if you would have asked me in 2014, when Mt. Gox filed for bankruptcy, if Bitcoin would have been double the price that it was then, I mean, I don't know if people want to bank on that. And that's kind of the issue going back to Celsius, right? Because when they went to court a few weeks ago, they said that they were either going to offer pennies on the dollars to the unsecured creditors, or they would offer long-term positions in the company. That's tough, man. That's tough because I mean, you're basically saying you can get out now and get pennies on the dollar, or you can, hopefully we're able to do whatever we say we will do, and then you will get paid, a little bit more in the future. Whether
Well, isn't
that's going
that
to happen or not,
almost the same thing if they're just
yes,
banking on the
that is
price going up?
literally the same thing.
Are
Literally
they
the same
going to
thing.
hold the
It's
pennies, or are you going to hold the pennies in cryptocurrency, right?
right,
And hope it
exactly.
appreciates. So,
Right, exactly. So they're basically saying, let us hold the money. We know what's best for you, even though they're over here telling you, don't look at our terms of service because you gave your rights away on your crypto, right? At least for the earned customers. The custody customers, it's a little bit of a gray area.
And that kind of brings me to another question, is that Celsius did state that you gave up your rights when you signed their user agreement. So that does hold
Right.
up.
Yeah. Yeah. I mean, and so let me take a step back. So usually, right, when you deposit funds into a bank, right, you create a custody relationship with the bank, right? And usually banks, you're protected by the FDIC up to $250,000. So if that bank goes defunct, then at least the FDIC steps in as a liquidator, and then you're assured to get your money back at least up to $250,000, right? That really didn't happen here, right? Because Celsius has two programs, right? They have their earn program, which their terms of service basically says you gave up your rights to the title in the crypto. There is no question about that. The custody terms of service, the custody service says you retain the crypto, that you have ownership to that title at all times. However, if we happen to file for bankruptcy, we don't know what's going to happen. That's literally what the terms of service says, right? And when I read that last night, this is kind of just a brush up. I kind of took a step back and I said, wow, I mean, they knew exactly what they were doing, man. They were taking high risk. I mean, I get it, high risk, high reward, but they knew exactly what they were doing when they wrote these terms of service. It is unsettled law. Unfortunately, it is unsettled law, right? So in a case like Celsius, the court will more than likely request that this issue be briefed, right? And as far as we know, Celsius's position is basically saying we don't know and we have no position. We're just going to let the courts decide. Even if the courts decide, you know what, this money belongs to the custodian customers, what happens if Celsius doesn't have the money to pay them back? Now they really just have an unsecured claim against Celsius, and now we're back at square one, right? But at least the law will develop, right? And maybe that'll trigger for companies to really write the terms of service, right in the terms of service, what's really going to happen in a bankruptcy situation.
or hopefully users will be a little bit more aware of the terms of service and not just click through. But
absolutely, man. I mean, it's such a hot button issue all over the place because so it's literally millions of people that have lost all their savings. I don't know if you guys have seen some of those letters that have been sent over to the Southern District of New York. People are basically suicidal. They're lost their farms, their houses, their life savings. So it's really a sad situation, and that's what I call the dark side of bankruptcy.
Now, going off of that, can people sue? Will they get anywhere if they press charges during bankruptcy?
So, yes, they can sue, but any lawsuit will have to go through the bankruptcy proceeding. It's called an adversary proceeding. So, going back to the investigations into the pre and post petition actions of the debtor, right? Creditors do have the right to subpoena management, to request for information and documents. It's called the 2004 subpoena within the bankruptcy world. And you have the right to investigate the finances of the company before it filed for bankruptcy and continue to investigate those same actions post bankruptcy. And so you have the right to depose people, ask for documents. So based on all of this, you will start to see whether the company mismanaged. Maybe they took risks that weren't really up to standard, right? Maybe they had some accounting issues. Maybe, they find assets that weren't disclosed in a bankruptcy, right? Which would be akin to bankruptcy fraud, right? So if any of these things come out, right, especially like some of the things that Key5 brought up in its lawsuit about misappropriation of funds, being a Ponzi scheme, mismanagement of funds, then that creates a problem. And if it's something that comes up where the company's actions were fraudulent, then yes, the creditors do have the right to sue Celsius in the bankruptcy proceeding. But again, that just prolongs the process, right? And the outcome of that, it's either to declare that specific debt non-dischargeable, meaning that you won't get rid of it through bankruptcy, or forces the office of the trustee and the court to, appoint a trustee and maybe force it to liquidate.
All right. So I think going from there, I'm going to switch it over to Andrew. Appreciate everything that you've given us, Carlos.
Again,
man,
take it away.
Super in-depth. This is exactly what we needed. But Andrew, let's get into some of the tax side. This is the biggest question, and I know we've answered it multiple times. Can you claim losses from Celsius?
So the short answer is it depends. In the tax code, the investments or the debts held by Celsius are likely to be considered non-business bad debts because you're typically not a business that made those loans to Celsius. So it's a non-business bad debt. And under the tax code, in order to take any sort of loss for it, it needs to be considered worthless, not in part, but in whole. It needs to be considered worthless. And if with the advice of a tax practitioner and reviewing the situation, you deem it to be worthless, then you'd be able to take a capital loss for your cost basis. And this is a really important point because people often say to me, well, I lost X amount of value in Celsius. And under the tax code, even if it was considered worthless, the most amount that you'd be able to take a loss for is what you actually spent for it or your cost basis, not what it's worth today or even at the time of bankruptcy. But the question really comes down to, is it worthless today or is it worthless at the time of filing your tax returns, or when will it become actually worthless? And so I think Carlos gave us a lot of great information today. And it sounds like, unfortunately, we're uncertain at this point. We all have suspicions that it's going to be pennies on the dollar, but we don't have the plan. And who knows, maybe at the time of filing the plan, the market goes to the moon and everything is resolved. I mean, that happened with Mt. Gox years later, but who knows? And it's that ambiguity, which from a tax perspective, at least in our assessment, it's hard to say it's worthless today, but maybe that point comes soon. And so at that point, then you can take that tax loss, but I would advise talking to a tax professional, an attorney or a CPA about that. Because if you do consider it worthless and you do take the loss and later you receive anything back, even if it is pennies on the dollar, whatever you receive back will be considered income and taxed to you at the fair market value of when you receive it then. And so at best, you're now able to take a capital loss for your cost basis. But if it comes back, you're going to have this very negative consequence of income at the fair market value. So long story short, you should be cautious to consider it worthless because as we saw with Mt. Gox, people got paid back. And we had clients that, for years after Mt. Gox's bankruptcy, then considered it worthless. And then a couple of years later, well, now all of a sudden, people are getting paid out. Right, exactly. So you don't know what may happen. And once that then comes back and it's skyrocketed, then damn, you've got a big taxable event, which nobody here wants to happen. So things to consider.
Now, I was going to say, let's worst case scenario here. You don't get anything back. You lose tons of your funds. What are some of the options for paying your taxes?
Sure. So, and what we're seeing with Celsius, which is very unfortunate, is that they issued tax forms for the interest that you received over the years. And now you're going to be paying tax on that interest, and you don't even have access to it. And that's just one of the negative consequences. But overall, we're also seeing clients that perhaps because of trading or other activity, they had gains in prior years, parked their holdings on platform like Celsius and Voyager to receive interest, now can't pay their taxes because it's all locked up. And this is one of the biggest misconceptions that people have, which is that they should just not file or avoid the situation, when in fact, the IRS is very willing to work out payment plans. In the context of individuals, if taxes are your only concern in terms of debts, bankruptcy, sorry to say this, Carlos, is usually not a good option, that there are better options for you. The IRS will work out a payment plan or even settle at times for pennies on the dollar. Bankruptcy is usually a last case resort, but even then, I believe it's you can't discharge the last 3 years of taxes. Is that right, Carlos? So
correct. And on top of that, there's certain things that you still have to meet, right? So even if you can get rid of anything that's over 3 years, but in those, anything older, you've been audited in the past, or you have a secured, the IRS or the state has a secure lien on your assets, that has to get paid back to the bankruptcy. So you're absolutely right. When it comes to taxes, bankruptcy should be the last resort.
Yeah. So there are options though, and we work with clients on a daily basis in getting payment plans or lump sum settlements. And some of our clients are banking on the price of crypto going up. And so they choose, well, rather than liquidate my holdings today to pay taxes, I'd rather get into a payment plan and pay over 6 years and liquidate a small portion every month. That is an investment decision, and we're not investment advisors and not giving financial advice. But if that is something you choose to do, at least we could provide options to you that if you don't want to liquidate everything today, we do very frequently get into actually 6-year payment plans with the IRS, where you just pay monthly across 6 years.
All right. And with that, gentlemen, kind of want to wrap things up here. I want to know if either of you have any final thoughts about anything that you'd like to talk about or touch on one more time.
I've got a question for Carlos, if you don't mind.
Sure, man. I'm happy to talk bankruptcy all day, man.
Yeah. So Celsius and Voyager, they're sending out emails even identifying that you could file a claim. How important is it if you were just, a holder, either using the earn or custody platform on Celsius, for instance? How important is it to actually file that claim versus just expecting that the bankruptcy court is going to have your information and hopefully one day you get a check?
So I usually tell all my clients, when I represent the creditor on the creditor side, I always tell my clients, file a claim no matter what. More than likely, your claim will also be scheduled on a petition, right? But the proof of claim really cements that claim against the debtor, and it really lets the world know and puts the world on notice that you hold this claim because it's public information, right? When you file bankruptcy, all of that information is public. So when you file a claim, it's the same thing. So when it comes to custody customers, I would absolutely recommend that they file, because you don't want to leave it up to the courts, or you don't want to leave it up to Celsius. I mean, someone in Wisconsin could be owed $5,000, and because they didn't file a proof of claim, they missed out on $5,000 that maybe they were really relying on prior to Celsius filing bankruptcy. With the earned customers, as we discussed before, the terms of service is pretty clear as to what belongs to you and what doesn't belong to you. But I would still file the claim anyway, just because, as we said with Mt. Gox, right? I mean, if right now, like 2014, Mt. Gox, proposed to pay nothing to its unsecured creditors, and then years later, we have $9 billion to basically pay out everyone, right? So you don't want to get caught in a situation where, because there are deadlines to file a claim, right? They set certain deadlines to file a claim, and then certain deadlines to object to that claim. So you don't want to get caught, in that situation where you kind of forget to file your claim, and then years down the road, Celsius is making distributions, you miss the boat, right? You don't want to get caught there. And for custody customers, I mean, this is unsettled law. So if the court says this asset does belong to you and forces Celsius to pay this money back, if you don't have a claim, then how is Celsius going to pay you, right? So that's very important.
Oh, that's great advice. Thank you.
Absolutely, man. Happy to help, man. Just my final thoughts is basically, again, you can reach out to me on Twitter. I'm here to answer any questions for free. I love talking bankruptcy, and I think what's happened to people involved in Voyager 3AC and Celsius is heartbreaking. I became an attorney to help people, right? Mainly in bankruptcy. I've seen it from big business to small business to mom and pop shops to people just filing because they don't want to lose their homes, right? And I try to help as many people as possible. So if you are a Celsius customer and you don't know what to do, just reach out to me, and I don't mind talking to you. Happy to help.
Carlos, greatly appreciated. I know that you're going to have a lot of people reaching out to you that are going to be watching this. So yeah, I guess to echo Carlos's statements, although people often don't think of tax attorneys as doing helpful things, one of the things that we really try to do is look out for our clients and make sure that you're using the tax code to your advantage. Taxes can be 30-40% of your gains or your income. And so to the extent that we can minimize that, you can have substantial savings, sometimes even better performance than the market by just having tax efficiency. So feel free to reach out to us. If you have questions, comments, please continue to leave them on this video. Even afterwards, we're going to be checking them and trying to respond to as many as we can. Yeah, thank you, Carlos. It was a great conversation.
Thank you, guys. Thank you for having me.
Yeah, thank you both. And like you said, if there's any questions or anything, put them on this post. We'll go through, answer them as quickly as we can. But tune in next week as well. We'll be live again. If there's anything that you'd like for us to talk about, also leave a comment. And if you also have a name for the show, some sort of suggestion, that would also be helpful. But guys, I really appreciate you doing this. And thank you.
Thanks again, guys. Speak to you soon.